We clean them here. People, we can go pick them up or people bring them in. We do them every Wednesday. And then we put them in a drying room. And by the following Wednesday, you should be able to pick it up. Okay, now that depends on how much load we have. We
Hello? Yeah. Hello. I don't know how to work this. I hope this.
Hello,
Hello.
good morning.
Good morning, sir. Can I? Hello.
Can you hear us?
Oh yeah, I can hear you now.
Okay.
Is this about my
Well, I'm here just as much as you are for the um, building standards meeting.
Yes, because I came down and applied for the 6 months extension. I repaired the gutter boards, and then the weather changed, and so all I got to do is put the gutters up and replace the piece of siding in the front of the house.
Yeah,
The
I
I
understand that, sir. Sir, I'm the same as you. I'm here to answer to this board. I'm not the board.
Oh, okay.
Okay. Um, so we are here just as much as you are. I'm waiting for the building to come on here.
Oh, okay.
Okay.
Yeah, because I believe the inspector came and took a picture of what I had already done. He did that a few days ago.
Yeah.
And so I think I'm in compliance, I hope. I mean, I hope I'm doing what I'm supposed to do.
Yeah. I mean, again, you asked for an extension. I don't see, we asked for the same thing. My owner of his apartment, his condo had a fire, and we asking for an extension for the repairs.
Okay.
So,
I thought when I had came down and applied for that, I thought that would have been done, but
yeah.
obviously not. But, okay.
So we have to wait here.
All right, no problem. I set aside this day just for this moment.
Yeah. So we.
Yeah, I'm supposed to be at work right now, but okay.
Are you
I hope this
Marcus Prince?
Yes, I am. I'm Marcus
Yeah.
Prince.
All right. Well, because there's other people coming board. There we go. Other people. All right.
Just working on it.
So I put some mute this. See, these people are in here. You still there, Marcus?
Yes, sir.
Okay.
I don't know how I got switched to the bottom picture. I don't know what happened. I didn't do it.
Well, you're next to me.
Happy Wednesday, everyone. Can you guys hear me online?
Yes.
I need you all to mute your mics until your docket is called. We have not started the meeting yet. We do hear you. We do see you on the feed. So please be patient with us until we get the meeting started. Thank you.
Okay. I can no longer see anyone.
Uh-oh.
Oh,
We can
okay.
hear you.
Mr. Prince, we can hear you and we can see you. You. Yeah. So once your docket is called, that's when you will unmute your mic to present your case, okay?
Okay.
Thank you.
All right. Thank you. You're welcome.
Good morning again. Happy Wednesday, everyone.
Morning.
Keep your microphones on mute until your docket is called. Once your docket is called, you will hear a brief description on what's going on with the docket. You will then be sworn in. And that's when you'll be giving your testimony.
Okay.
Mr. Prince, your mic is hot, so if you can mute your microphone, please, so we will not get your background feed.
Okay. I don't have any noise going on, but I can.
But I still need you to mute your microphone. I greatly appreciate it.
No problem.
Thank you. Mr. Chairman, we can proceed with the preamble.
Okay, in compliance with the notification requirements of Ohio's open meeting law in section 101.021 of the codified ordinances of Cleveland, Ohio, 1796, notice of this meeting has been publicly posted. All boards and commissions under the purview of the City Planning Department conduct their meetings according to Robert's Rules of Order. Actions during the meeting will be taken by voice vote. Abstentions from any vote due to a conflict of interest should be stated for the record before the taking of any vote. In order to ensure that everyone participating in the meeting has the opportunity to be heard, we ask that you use the raise hand feature before asking a question or making a comment. The raise hand feature can be found in the participants panel on the desktop and mobile versions and activated by clicking the hand icon. Please wait for the chair or facilitator to recognize you and be sure to select unmute and announce yourself before you speak. When finished speaking, please lower your hand by clicking on the raise hand icon again and mute your microphone. We will also use the chat feature to communicate with participants. The chat feature can be activated by clicking the chat button located at the bottom of the WebEx screen. All meeting activity is being recorded by way of the WebEx platform. These proceedings are also being live streamed by way of YouTube. All requests to speak on a particular matter by way of our website and email have been considered. We have also received emails from those who have provided written comments on a particular matter. Mr. Jacobson.
Thank you, Mr. Chairman. This is Dan Jacobson from the Law Department. Preliminary issues, the live stream. Can we verify that the live stream is on and functioning?
Through the chair, yes.
Thank you. And Mr. Chairman, as the Law Department has done since these public meetings have gone virtual and are hybrid, law states its objection to the use of the chat function. Thank you.
Okay, thank you. Ms. Davis.
Mr. Bradley,
Yes. Here.
Mr. Dink,
Here.
Ms. Lipscomb,
Here.
Mr. Gallagher.
Here.
We have a quorum.
Okay, we'll call the first case, building docket A186- wait a minute. Hold on just a minute here.
We're gonna do 189. We're
Yeah.
having some delay over here in it with the link, so give it a second to catch up.
I'm sorry. I don't know if anyone called for TCM Enterprise Management, but I'm here also.
Okay, no one's called for you, so mute your microphone until you hear your docket call.
All right, thank you.
Thank you.
So we're good to go with the housing docket A189-24, 4456 West 47th Street.
Application and fees are in order. Notice of violation is exterior maintenance. Issued on September 18th of 2024. Appeal was received October 18th of 2024, requesting for 30 days to complete abatement of the violations. Present for today's hearing, Chief Building Official Tom Vanover, Dan Jacobson Law. Will the applicant or his or her attorney and or representative please state your name for the record? Mr. Gallagher, 1 second before we move forward. I don't see the court reporter. 1 second.
Sure.
Mr. Chairman, we can go ahead and proceed.
Okay. We're looking for someone for, let's see, yeah, for 18924. Is there,
Okay, I do not see the appellant in the participants panel, nor is that person present in room 514 this morning.
okay. Mr. Vanover? Do you, swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Councilman Chris Harsh is also here this morning, Mr. Chairman.
Okay, all right, we'll go to him before, Mr. Jacobson, right? Okay,
No.
Swear him in, please.
okay, Councilman, solemnly swear to, or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, go ahead.
Yeah, I would just encourage the board to reject this appeal with prejudice. We have done everything in our power to talk to this lady about cleaning her house. I've spoken to her face to face many times. She has numerous teenage children in the house. There is no physical barrier to her cleaning the front of her house. She generates more calls to my office than almost anybody else in the neighborhood with just insistent filthy living. And all we're asking is that she clean the front and move the trash cans to the back. Simple code. She refuses to do it. She apparently has more time to file an appeal than to even clean her own front porch. So I would encourage this board to reject the appeal and carry forward with the citation.
Okay, thank you, Councilman. Mr. Jacobson?
Through the chairman to Ms. Davis. What is today's hearing concerned for the board's file for any reason?
Through the chair to Mr. Jacobson, Steve Hilton declined the meeting link this morning for this meeting. So the notice was delivered. They declined to attend today.
Steve, was it Stephen Hilton that declined the invite?
That is correct. That's the email address that was presented to the board for notifications of hearing.
And you said you received any other form of other emails or messages or anything else physically delivered to you on behalf of the town team on that?
Through the chair to Mr. Jacobson, no.
Thank you, Ms. Davis. To the chairman, the due process requirement of notice having been given to this appellant, the board can proceed with the hearing and ruling today. Thank you.
Thank you. Mr. Vanover?
Mr. Chairman, we ask that you deny any more time and remand it back to the Department of Building and Housing. This was issued in October. They requested 30 days. We are well beyond that. So we ask that you deny time and remand it.
Motion is in order to deny more time, remand the property Division of Building and Housing for any further action. Motion,
So moved.
moved by Mr.
Second.
Bradley, second by Mr. Dank.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Ms. Lipscomb,
Yes.
Mr. Gallagher.
Yes. Okay, notification will be sent out in 2 weeks. Thank you.
Thank you much. Appreciate y'all.
Back to the top, Ms. Davis.
Yes, sir.
Okay, billing docket A 186-24, 10301 Lake Avenue.
Application and fees are in order. Notice of violation is fire damage issued on September 5th of 2024. Appeal was received on October 24th of 2024, requesting for 6 months to complete abatement of the violations. Present for today's hearing, Tom Vanover, Chief Billing Official, Dan Jacobson Law. Will the appellant or his or her attorney and/or representative please state your name for the record?
I'm Paul Casado.
Okay,
I'm
Mr.
the owner. I'm the owner.
You're the owner. Okay, Mr. Casado, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, go ahead and let us know what the plans are.
Our plans are to completely redo the condominium, and we'll have about 6 months before it's completed.
Okay.
I have the building permit.
Okay, and you have the permit. Okay, very good. Mr. Vanover.
Mr. Chairman, to the appellate, can you provide me with the building permit number?
Yeah, certainly. Permit number is B as in boy, 25002935.
Okay, I apologize. This address comes up with everything for the condos. So, yeah, Mr. Chairman, there is a permit in place. And it appears that MD Disaster Services is the contractor on board. So we wouldn't object to 6 months for compliance based on the residential code of Ohio, or the
Okay.
Ohio Building Code.
Sounds good. Motion is in order for August 28th, 2025, to abate the violations. Motion.
So move.
Okay, moved by Mr. Bradley,
Second.
second by Mr. Dank.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Ms. Lipscomb,
Yes.
Mr. Gallagher.
Yes. Notice will be sent out within 2 weeks. Next docket is housing docket A 180-24 13216 Harvard Avenue.
Application and fees are in order. Notice of violation is exterior maintenance, issued on September 6th of 2024. Appeal was received on October 1st of 2024, requesting for 6 months to complete abatement of the violations. Present for today's hearing, Chief Billing Official Tom Vanover, Dan Jacobson Law. Will the applicant or his or her attorney and or representative please state your name for the record? Mr. Prince, you have to unmute your mic.
Yes, my name is Marcus Prince.
Okay, thank you. Mr. Prince, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, very good. Go ahead and proceed. Let us know what your plans are.
Okay, well, I repaired the gutter boards. I mean, as you can see in the pictures, I took the old ones down and put the new ones up, and then the weather just went sour on me. And I've got the siding in the back of my house to repair the front, and I'm gonna put the gutters up. I mean, as soon as the weather gets right. I mean, I have to do it myself.
Okay, so you're gonna need more time to complete this. How much more time do you think?
I mean, honestly, probably maybe just another month or so. As soon as the weather gets right, I've been out of work. I'm a self-employed contractor.
Okay,
And whether, I mean, hey, I've been home, and I'm a single father. I have 2 teenage daughters, and money's been tight. Because if I'd have had the money, I would have fixed it already. I had the gutter boards on the top of my van when the violation came. I had planned on fixing it anyway.
now you live here in this property, correct?
Yes, sir. Me and my 2 daughters.
Okay, very good. Mr. Vanover.
Mr. Chairman, we don't object to 90 days to abate the violations.
Okay, so motion is in order for May 28th, and be 90 days, 2025 to abate the violations. Motion?
So moved.
So move.
Okay, moved by Mr. Dank, second by Mr. Bradley.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Ms. Lipscomb,
Yes.
Mr. Gallagher.
Yes, notice will be sent out within 2 weeks. Thank you. Next docket is housing docket A 181-24 3464 East 108th Street.
May I ask a question?
Yes,
Am I done here or what?
you are done, sir.
Yep, please reach out to your inspector to follow up with inspections.
Okay, thank you. So I can end this call, right?
Yes,
Yes.
Okay, you all have a great day. Thank you.
thank you.
Mr. Chairman,
Yes,
Can we hold docket 18124? I believe Councilwoman Gray wanted to come up.
Sure. Okay, we'll go on to the next docket. Housing docket A 182-24, 2062 East 115th Street.
Application and fees are in order. Notice of violation is exterior maintenance. Issued on September 13th of 2024. Appeal was received on October 7th of 2024, requesting for 1 year to complete abatement of the violations. Present for today's hearing, Chief Billing Official Tom Vanover, Dan Jacobson Law. Would the applicant or his or her attorney and or representative please state your name for the record? Yeah, you can come up. State your name for the record, please.
My name is Arthur Bird.
You can pull it closer to you.
Oh, okay.
Okay, that was Arthur Burr.
Yes,
Okay, Mr. Burr, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, go ahead and let us know what the plans are.
Well, my porch, I can get fixed. All that cleaning up. My kid's mother, fiance passed away. That's why she brought all that stuff over to my house. And all in the backyard and stuff, and got it all thing. So I'm gonna clear all that, most of that clean up. The dude that's supposed to fix my back porch, he cut the trees off of my house, and one of the trees fell on him. He broke his collarbone and all that, and I don't know really how to get in touch with him. So I had to get that back porch fixed, clean up the backyard, and whatever else I got to do. But I might need more time than a year.
Okay,
Because I don't have the money to do exactly everything y'all want me to do. I've been trying to get help. I've been calling around, ain't nobody called me back or nothing like that. So
do you live in this house?
yes, I do.
Okay. Okay, so how much more time do you think you need?
Just another year, because the money's kind of funny right now, and the weather's really stopping me for doing anything. And I got some friends that do that kind of work, and they, you know.
Okay,
Soon.
all right, let me go over to Mr. Vanover. Mr. Vanover,
Mr. Chairman and Ms. Davis, can you give me this address again, please?
To the chair, to Mr. Vanover, 1731 Hillview.
Okay. Bear with me. Mr. Chairman, to Mr. Byrd, have you reached out to the City of Cleveland Department of Aging?
I done called a lot of people. I don't know who really calling, and try to give me some help to come out there and help, you know, give me some kind of help to get this stuff done. But every time I call somebody, they don't answer the phone. They don't. I leave a message. They don't call back. I've been calling for.
Mr. Chairman, as an owner-occupied structure, we don't object to, we always object to a year because that just gets us right back into the winter months. But we don't object to 6 months to make the corrections on this property, and I will refer it to Inspector Shockley at the Department of Aging.
okay, that'll help. Okay, so we're looking at August 28th for 6 months, 2025 to abate the violations, and hopefully with Officer Shockley's help, you'll help you get this thing taken care of. Motion is in order.
So move.
Okay, moved by Mr. Bradley,
Okay.
Second.
second by Mr. Dank.
Mr. Bradley,
Yes.
Mr.
no.
Dink,
Yes.
Ms. Lipscomb,
Yes.
Mr. Gallagher.
I'm through.
Yes. Okay, notice will be sent back out to you within 2 weeks. Thank you. You're all set.
Ms. Davis, I'm assuming we have a good phone number?
Yes, we do.
Thank you.
Okay, housing docket A 185-24, 9905/07 Zimmer Avenue.
Application and fees are in order. Notice of violations is no permit, non-compliance, and a stop work order. Issued on September 24th of 2024. Appeal was received October 11, 2024, requesting for 8 months to complete abatement of the violation. Present for today's hearing, Chief Billing Official Tom Vanover, Dan Jacobson Law. Will the applicant or his or her attorney and/or representative please state your name for the record?
Tammy Gibson.
Okay, Ms. Gibson, you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay, go ahead and tell us what your plans are.
Okay, currently I no longer own the property.
Okay. Let's see. All right, so I'm gonna go over to Mr. Vanover. Mr. Vanover?
So, Mr. Chairman, then, with that information, we would ask that you deny any time, remand it back to the Department of Building and Housing for further proceedings. There was a lot of work done on this house, that wasn't properly permitted, and the appellant sold it to somebody else or transferred it to somebody else, with the illegal conditions. And as I've stated many times, simply transferring the property does not relieve the appellant from the responsibility for making the corrections.
Okay,
I didn't sell the property. I did a deed in lieu, so I just gave it back to the lender.
Okay.
okay. Well, the same thing stands, right? The motion to is in order to deny more time and remand the property division of building and housing for any further action. Motion,
So move.
moved by Mr. Bradley,
Second.
second by Mr. Dank.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Ms. Lipscomb,
Yes.
Mr. Gallagher.
Yes, notice will be sent out within 2 weeks. Housing docket A 187-24, 3312 West 38th Street.
Application and fees are in order. Notice of violation is exterior maintenance. Issued on September 16th of 2024. Appeal was received October 15, 2024, requesting for 6 months to complete abatement of the violation. Present for today's hearing, Chief Building Official Tom Vanover, Dan Jacobson Law. Would the applicant or his or her attorney and/or representative please state your name for the record? Mr. Chairman, I do not see the applicant in the participants panel, nor is that person present in room 514 this morning.
Okay, Mr. Vanover, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
And Mr. Jacobson?
Thank you, Mr. Chairman. Through the chairman to Ms. Davis, did notice of today's hearing get returned to the board's file for any reason?
Through the chair to Mr. Jacobson, no.
And through the chairman to Ms. Davis, have you received any form of communication, an email, a voice message, or anything physically delivered to you on behalf of this appellant and or docket?
Through the chair to Mr. Jacobson, no.
Through the chairman, the due process requirement of notice having been given to this appellant, the board can proceed with its hearing and ruling today. Thank you.
Thank you. Mr. Vanover?
Mr. Chairman, that being said, information provided, we ask that you deny more time and remand it back to the Department of Building and Housing.
A motion is in order to deny more time, remand the property division of building and housing for any further action. Motion
So moved.
moved by Mr. Dank,
Second.
Second.
second by Ms. Lipscomb.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Ms. Lipscomb,
Yes.
Mr. Gallagher.
Yes, notice will be sent out within 2 weeks. Next docket is housing docket A 188-24, 10409 Harvard Avenue.
Application and fees are in order. Notice of violation is exterior maintenance issued on September 4th of 2024. Appeal was received on October 15th of 2024, requesting for 90 days to complete abatement of the violations. Present for today's hearing, Chief Building Official Tom Vanover, Dan Jacobson Law. Would the applicant or his or her attorney and or representative please state your name for the record? Mr. Chairman, the applicant is not in the participant panel online, nor is that person present in room 514 this morning.
Okay, Mr. Vanover, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, Mr. Jacobson?
Thank you. Through the chairman to Ms. Davis, did notice of today's hearing get returned to the board's file for any reason?
Through the chair to Mr. Jacobson, no.
And through the chairman to Ms. Davis, have you received any form of communication, an email, a voice message, or anything physically delivered to you on behalf of this appellant and or docket?
Through the chair to Mr. Jacobson, no.
Through the chairman, the due process requirement of notice having been given to this appellant, the board can proceed with its hearing and ruling today. Thank you.
Okay, Mr. Vanover?
Mr. Chairman, we're gonna, based on just the photographs, we're gonna ask that you deny and remand it back to the Department of Building and Housing.
Okay, a motion is in order to deny more time, remand the property division of building and housing for any further action. Motion,
So move.
a move by Mr. Bradley,
Second.
second by Mr. Dank.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Ms. Lipscomb,
Yes.
Mr. Gallagher.
Yes. Okay, notice to be sent out within 2 weeks. Next docket is an adjudication order building docket A 183-24, and it has been withdrawn. The next docket is
We did
another
that one.
adjudication order building docket
It's
A
withdrawn.
037-25, 3349 West 25th Street. And it has also, it's been postponed. Okay, we have all the information on them too. So under the Department of Public Safety, Division of Fire, cease use of operation building docket A 042-25, 620 Frankfurt Avenue.
Application and fees are in order. This is a cease use of operation issued by the Department of Public Safety, Division of Fire. The order was issued on February 13th of 2025. The appeal was received February 19th, 2025, requesting for 14 days. 1 second, you guys can go ahead and take this side. Present for today's hearing, Chief Building Official Tom Vanover, Dan Jacobson Law. We have personnel from the Division of Fire here. If you guys can unmute your mic and say your name for the record.
Dave Talbin, Fire Marshal.
John Wakey.
Will the applicant or his or her attorney and or representatives please state your name for the record? So you guys unmute your mics. If you all are going to give testimony today, you must say your name for the record, please.
Attorney Daniel Thiel.
Willis Tabron.
Racine Parker.
Michael Carrara.
And Jeanette Sharara.
Mr. Chairman, did you get that?
Yes.
And Mr. Chairman, I'll need to be sworn in as well.
Okay, so we're going to swear everybody in that's going to be giving testimony. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
I do. I do.
I do.
I do.
Okay, so we do have an issue, I think, that's still standing is on the issue of peril by the city. Is that correct?
Mr. Chairman, I believe we're here today for the cease of use order.
Okay, so there wasn't an issue put out on peril. Is that correct by the city? Mr. Vanover?
Yes, Mr. Chairman, there was, that is correct.
Mr. Chairman, this is actually a fire order. If you could request that from public safety. Mr. Vanover was not the one it was the affiant that filed with this board. It was the fire department, if we could.
Okay, and that was with peril from the fire department. Is that correct?
Yes, sir.
Okay, then we need to clarify that up as to why it became one of peril. So who's ever going to speak for fire, go ahead.
Okay, when the cease use was issued, it was due to the fact that there were hazardous issues within the structure of the building. Under our information provided to us, there wasn't a certificate of occupancy that was current. And through our code, the business would have to be sprinklered under a couple different codes situations, and they were not sprinklered to be operating, which they were already operating. The first time we were notified was that the kitchen was in full operation and the hood had not been inspected by the mechanical inspector or commissioned by the fire inspector as of yet, but it was still being used. And then at that time, we were brought in and we were looking at the configuration of the egress pathways inside the building, which changed drastically from the previous blueprint. It looked like a full demolition has taken place from reading the demolition permit. And the secondary egress was in question because there's the pictures up on the board now of what the club used to look like back in 19. This was about the time of the NBA All-Star game when these photos were taken. So as you can see, the one on the left is where the front door, which would have been the primary egress, and unfortunately it doesn't have a good shot of the secondary egress. It would be in the other end of the room. If we could go to the other pictures from let me see here. We could take a look at picture number 1. This diagram. Did you have?
Yeah, keep going.
Going back to the beginning here. Okay, all right, this is a picture of the plans that were submitted. As you can see, the right would be the front or south end of the building. To the left would be the north end of the building. There is a secondary egress at the northwest end there. That little driveway going out there is where it's proposed. And then the main egress is at the front. You'll see the doors next to the bar. As you can see, by looking at this diagram, there looks to be a considerable amount of space between the stage and the fixed seating, and as well as at the south end of the stage. But once coming in, if we can go to one of the pictures of the next one of the interior. No, not that one, the regular pictures. Yeah, that up there. Okay, as we can see here, along the stage, there is seating, which narrows that space for egress down considerably. And the reddish picture on the bottom, second from the left, that is a large booth that is at the south end of the stage. As you can see, the picture right up, now go back to, stay where you're at. The picture right above that also shows that direction. And if you look to your right corner where those yellow seats are, that's where the primary egress is. And then we know most people enter and leave the way they come in. So that's where people are going to go. And with that booth at the end, it considerably shrinks down our egress pathway. As we can see down, and the picture on the left, on the top left there, that part, if you're in that part of the bar, due to the spacing where the stage is, the egress is on the other side of the stage. In that corner to the left of the steps, right about there, there's double swinging doors in that place and then the egress. So if those doors are closed and people push the door open, it covers the egress opening that obstructs it. People that are in this corner, they would need to either walk all the way around the stage or be able to climb over the stage to get to the secondary egress if there was something at the primary egress preventing people to exit in that way. That is the dangerous part there. As you can see on the top row on the right, you can see the swinging door, the gray door that I'm talking about. And if you can see just past that gray door, it looks like a switch on the wall. That's where the egress is to go down. And if those double doors were to close, you wouldn't even see the egress there. And as you can see in that picture, the exit sign was on the sidewall. And from the front of the house, if you look at the bottom left picture, you can't even see any posted exit sign at that point. Above the steps, I believe there's a dressing room, and they want an occupancy of 49 people up there. And the only egress is to come down those steps. If we could go to the next set of pictures. Okay, the top picture to the left is the end of that northeast corner where the people would either have to go over the stage to get across. That area there, that little doorway behind the chair, is supposedly the way people can get to the egress, but is substantially smaller, and the egress pathway cannot be narrowed as you're walking through it from point A to the egress and exiting out. The top picture on the right is the egress. As you can see, the swinging door on the bottom left corner of that's where that door is. As you can see, this is the condition it was in after they were open already. Also in that egress on the left there are two large, I'm not sure if it's a freezer or cooler, but there's mechanical equipment in there in the egress that could potentially catch fire and, cause loss of use of that egress itself. And down below, you have the picture with the bollards. That's the second from the right. That's the outside picture of that egress up above. As you can see, the two bollards that are out into the lane, those are bolted down. They could be removed with a ratchet. They're not permanently installed. We cannot find any recorded easement that states we have permission to use that parking lot because the parking lot is not owned by the establishment. I did some research and looking at the county site. They did have a variance to use that in 2013. In 2014, ownership changed hands on the parking lot. When you have an egress, you're supposed to have a clear path to a public way. And this is dumping the people into a parking lot, which either they're going to walk behind cars parked against the building or walk out into a lane of traffic if they have to exit the building. Is there another sheet of pictures? Is there anything you want to add, Lieutenant?
Just to reiterate what the fire marshal said about the means of egress has not been maintained from the original approval in 2013. They made significant changes to how you get out of the building, which most part that mezzanine level now is unusable. The exit access stairs come down to a stage. You have to walk across the stage past 3 dance poles to get to the front exit or the back exit. It doesn't terminate at the floor level. As you can see in the top left picture, or the third picture on the top row from the right. So that mezzanine level isn't even occupiable anymore according to the code.
Okay, and so.
Mr. Chairman, this is Patty. Lieutenant, can you repeat that again? About why it's not occupiable on the
Because
list?
it doesn't provide you, means of egress isn't it's, the exit access dumps you onto a stage. On that stage, you'd have to traverse to the end, which you have to navigate around 3 poles to get to the steps, and then turn either back towards the back or to the front door. It doesn't terminate on the floor level.
Mr. Chairman, it's Patty, if I can, Lieutenant, are you saying that it's different than what it was previously approved for? Is that what you're saying?
Yeah, absolutely. That stage was added since the approval of CF in 2013.
Okay.
I'd also like to.
Okay.
The exit discharge that was they had a variance on that exit discharge in 2013. It hasn't been maintained. Once you leave the building, they're obligated to get you to a public way.
Mr. Chairman.
To the public way.
Mr. Chairman, this conversation, the question is to describe the peril.
Yes.
That is involved for the order.
Yes.
The appellant made claims against the existing certificate of occupancy and the certificate of occupancy in place, and then now Lieutenant Wakey is speaking to building code requirements. And while this is a fire order for the cease use for the space, I think we're beyond the description of the peril, and we need, in the building code discussion, I should at least be able to opine on that.
Oh, yeah, that's absolutely.
And Mr. Chairman, that's not before this board.
Okay, so.
Mr. Chairman, I disagree, because the testimony provided by both the appellate and the fire service is that building code issues are what led to the peril.
That's for the board to determine.
That's why I'm presenting for my record to the board.
So preliminarily, Mr. Chairman, if you could make that determination.
Okay, so the determination would be that for peril, or for that something has changed?
I guess there's 2 questions. One, you're going to have to hear from the appellant as to the peril question, but as to the building code issues, whether or not that is before this board.
Well, it's not, I don't think it is, but.
Thank you.
Yes, the other board members, but I don't believe that is before us. I think that, we wanted to know, because what is before us, is this hood. That much I do know. But,
Chairman?
Yes.
This is Dave Talbot, Fire Marshal. As the configuration says, there is fire peril. It creates a hazardous situation or condition to exit the building.
Okay, well, let's go over to the appellants and see what they have to say about, any changes to this path.
Thank you very much. I appreciate being able to respond before we move on to any other issues so they don't get confused. And if we have to go that way, then, yeah, can everybody hear me okay?
Yes.
Usually we do this, they wanted an in-person hearing because this is very important to them. These issues have been litigated a number of times. There's 2002. There is actually a court order in Cuyahoga County, CV 02476634. Then again in 2007, there was another citation, and it was ruled again in the club's favor. Then again in 2012, Appeal A8612. This is a predominantly club of color. This is a club that we believe the city does not want to have because they believe it causes trouble or menace. And we believe that this is discriminatory, the actions being taken. We're going to go through the pictures that they have and show how this is not a fire peril. There's no reason to shut them down, and that they should be able to, have a proper time to have an appeal process, and that life and limb was not in presence since, they've been open. This club has been running for many, many years, and these changes anybody could have came in and said before, but they do admit to one thing, that they were incorrect with the hood. They had believed that inspection had covered it. They'll give testimony to that. And they did have the part put in for the hood. That is number 2 in the the citation. And so they will admit to that, but the hood, that issue has been remedied. The part is in, it just waiting for inspection. Section number, I'll just kind of go through all of them because there is a 6-count piece here and they probably each need to go. And then we wouldn't mind going through the pictures that you guys put, if you want to go ahead and put these pictures up, and we'll let them explain these. And there is just to go back, they'd asked for a variance to be able to use it. Here is, I don't know if you guys have seen this recorded. I'll give you this. This is a recorded variance for the party wall, it's called. It is old. I think this is from, what year is this from, gentlemen? 1900, early 1900s, but for your review, so the fire, they do have
Mr. Chairman, to council, are you submitting that to the board as an exhibit?
We will, and I think we did.
Okay, so she's gonna make a copy so they can have it in.
We have 3 copies if everybody'd like one, but just so you can take a look at it. Those bollards that they say are bolted down, good luck with that. They're pretty rusted in there. How long have those been in there, gentlemen? 20, 30 years?
They had ballards there before, and what they did was they added ballards in September.
Oh, they added 2 more?
They added 2 more, yes.
Oh, so there was 2 ballards there, and then now they've added 2 more, so there's 4 ballards that are there. So the new ones are bolted down. There's 2 ballards that aren't shown in that picture that are closer to the building, just to really prevent anybody from ever parking there. And so that is something that changed, but that was back. Now, when was that put in there? September, you said?
Mr. Chairman, if we cannot lead the witness, just so we don't have anyone complaining about it. Thank you.
When were they added?
They were added in September. If you go back to that last phase, if they click back, that text message on there is timestamped. It's timestamped from see that? It's timestamped right there. That's when it was added. That's from the parking lot manager. He texted me. If you look at what he texted me, he said, hey, we installed these to make sure that you have easement from your building. Referred to my contractor because I wasn't there. So he sent me a text message and told Mike that he needed access over here so that way he could install those ballards. So that's all right there. That's a text message from the manager of that parking lot.
Okay, and now let me ask you, they said about the door changing, the front door. Tell me and I would hope the board would love the changes they made. Tell us about the changes to the door. It went from how many inches?
So it went from 32 inches to 80 inches. When we went to the board, the committee to design the front, they made sure that they wanted it to be handicap accessible. They suggested that we have a double door opposed to the 32 inches. So we expanded to 80 inches. And on top of that, they also made me redo the curb so that someone with a wheelchair is easily accessible to get in and out of the premises.
So that's not the door.
That's the street.
You got to turn on your mic if you want to talk.
There was a curb.
Okay. Before you.
Yeah, we'll let you go.
State your name. So we can make sure court reporter is speaking.
Michael Corrala from MEK Construction, the general contractor on the project.
Go ahead and say what you want to say about. So this is not the door we're talking about. We're talking about the front entrance.
The front door, the front entry door. We installed a ADA ramp so people with wheelchairs can get up onto the sidewalk. And along that whole street, there's no access to the sidewalk for a wheelchair except in front of our building, their building.
And if the board will look at the 2012 appeal variance A8612, that dealt with that door. That door was a terrible door. It opened inwards instead of outwards. It was only 36 and it didn't even have a push handle, but the variance was the term grandfathered in for that door. That was the major change they wanted to make to this place. That was the big change for the front. And we believe that now being from going from 32 inches to, 80 inches, opening outward and having push button to be able to open really opened up this place a lot. and they just kind of feel like it's kind of like a gotcha sort of thing. Hey, you made changes to it, even though it's for the better. We're going to come in and now try to close this club down because we've been trying to do it since 2002, 2007,
Mr. Chairman, to
2012.
council, this is Patty, if I may. That's an egress doors that you're testifying to. Did you pull a permit for that work?
Yes. we did.
Affirmative.
Okay.
Everything that we did on this project, we pulled every permit. This door has been there for 40 years. This door that you see on the screen has been there for 40 years. We never touched that door of egress. That's the door that they talked about that's on the occupancy as far as the second means of egress. That's that door. I never touched that door at all. I never installed those ballards. That's just an agreement that they're abiding by with the old agreement with them by putting those ballards there. So that way we do have a second easement door.
Mr. Chairman, this is Patty again, and apologize, but they were referring to the prior board's resolution in 8612 to the appellant. Is the work that you did to the door that was referenced in the board's variance about being locked open during all periods of occupancy?
Affirmative.
Did you hear that, Mr. Chairman?
I did.
Mr. Chairman, I object to the statement that all the work that they did was permitted.
If we may continue on.
Yeah, go ahead.
Thank you. We don't have any citations for anything not being permitted. So Mr. Vanover jumping in and giving us this, at this time, we're not able to respond to that. Our clients believe they pulled all permitted. We have the construction gentleman here. We have the architect here. Could you guys opine on the permits that you've pulled and that you got approval for all of your plans?
Yeah, all permits that were necessary to complete this project per the approved plans that were submitted in April to the city of Cleveland Building Department.
And if I may, just these plans were submitted 5/8/23. The next one was 4/26/23, and
any issues with the plans were addressed and.
I'm sorry, one
Any
second,
eventual-
Mr. Chairman, to the appellant, could you please state your name
Yeah,
before
Racine
giving your
Parker.
testimony? I'm sorry, could you repeat it again?
Racine Parker.
what is your position?
I'm I represent the architectural team.
And did the architectural firm, can you just go ahead and tell us about the drawings and permits you want to talk about?
Yeah, we prepared these drawings last year, 2023, late 23, submitted in 24. Of course, we followed all the codes. The issue that they're addressing about the interior changes,
Do you want us to go to the
everything
pictures?
still addresses is to code with the interior changes as far as egress. The path of travel may have been changed, but as far as egress and exiting and exit passageways, exit pathways, everything is still to code. And it was even approved by the plan examiner last year and even recently with the recent addendum. So nothing as far as the exit passageways is out of code.
And you are swearing to this as the architect?
Yes, as the representative.
If we could go back to the
And
pictures.
Mr.
that they
Chairman,
showed.
if I could
Apologize.
interject. Mr.
I'm
Chairman.
sorry, are we going back and forth here on this, or can we just put on our case as you did?
Okay, I had a question that would probably help the case.
Okay. I'll go ahead and give lead.
I'm hearing through the chair to,
Dan, pull your microphone closer.
you've given testimony regarding permits. There seems to be a lot of interior work done. Is there a demo permit involved?
Yes, there was one pulled.
Okay. Or can you speak to that, to the extent of the demo permit?
One second, guys.
Contractor.
Please, before you give your testimony, because it's a lot of you guys giving testimony today, and so the court reporter will get this correct, please state your name before you give your testimony, okay? Thank you.
Thank you. Dan Jacobson from Law Department, through the chair to the appellants. You've given testimony regarding permits pulled. Could you clarify whether or not a demo permit was pulled and what was done?
Yes, a demo.
State
This
your
is
name,
Michael
Mike.
Corrala with MEK Construction, the contractor on the job. There was a demo permit pulled. The only walls that were removed were in the lobby when you first walk in. And that, by removing the walls, they had like a small narrow entranceway to this big space. By installing those two large doors in the front, created a larger lobby for customers to come in and leave. All the main walls in the building pretty much stayed. The bathrooms were already there. They were just reappropriated from a different room.
Does that answer your question, Dan? Through the chair to the council, I would like other representatives, particularly from fire, to opine on whether the changes affected the current state and hazards created through those changes.
I understand it's a very informal proceeding, but could we?
Mr.
provide a
Chairman,
comment,
this is
please?
Patty. Then that will be after he presents the rest of his case.
Very
Thank
good.
you.
Yes.
Thank you.
Thank you. I know this is an informal hearing, but as lawyers, we kind of get stuck in our ways. And so I'll try to, if I get lost or anything, or the board has any questions, please go ahead and stop and ask me. I don't know about presenting exhibits. They did talk about the occupancy permit, which is number 6. I don't know if everybody has the cease order in front of them, but I'd like to go through that piecemeal. We talked about number 2, where they admitted that they had believed they had the proper inspection for that. Once they found out they were incorrect, they immediately fixed the problem. They went ahead and pulled two permits for that, which I'll have them testify to, and they've got the part installed, and now they're just waiting for the permit. And so number 2 of the close order, Michael, would you like to speak to that? About the hood permit? So go ahead and state your name and then.
I'm Michael Corrala, MEK Construction Contractor. It was brought to our attention that the hood wasn't inspected. When I took on this project, the hood was there. Originally, there was a hood permit pulled prior to me taking the project on. And then we went ahead and fixed everything, and then it was brought to my attention that there wasn't any permits pulled for the hood. So I had Alpha Mechanical pull, originally I had Brian Petroselli pull a permit. There was a falling out with him, so we hired Alpha Mechanical to pull the permit, which the day that Alpha Mechanical came to see the job, they were there with, they had met Mr. Powers from the mechanical inspecting in the Cleveland Building Department. And him and Alpha Mechanical spoke. Alpha Mechanical pulled the permit. Alpha Mechanical fixed the hood. Alpha Mechanical is waiting on inspection for the part that we needed to finish this job.
All right. And says all
The first part of, there's a 2-part inspection on the hood. One is to inspect the welds, the ductwork going through the roof, which were inspected by Mr. Powers, and they were approved. He came back and inspected the insulation ramp. Now he's just waiting for the this part that needs to be installed for the hood.
And that is ready to be inspected today, is that correct?
Yes.
All right, thank you. Hopefully that clears up the issue number 2. That was the request for the 14 days because that was the only part that they believe that they knew that they had made an error. Go ahead.
Michael Corrala again. Mr. Powers also asked me to have Alpha Mechanical pull a permit for the gas line that was near the hood. That gas line didn't really technically need a permit because it was part of the original plumbing permit that was approved by the city. But we went ahead and did that again just to show good faith.
And I think that the reason that you guys got into this trouble, and I'll just kind of explain the background, is the person who pulled the permit was, you didn't believe that they were being honest with the city, correct? You want to go ahead and explain that?
Correct. We hired him to pull a permit and do the work. Brian Petroselli.
Okay.
There was an original permit pulled by him, and then Mr. Vanover, he spoke to Mr. Vanover and told Mr. Vanover to pull the permit because Brian Petroselli couldn't do the work.
What did he ask for you just to pull the permit?
$1,000.
Is he going to do the work?
No.
Okay, and that's what kind of led to all of this, is
Correct.
the permit being pulled because you wouldn't pay somebody $1,000 to pull a permit, correct?
Correct.
All right, and so that's what we believe led to all of this spiraling, is they decided to do the right thing and not pay somebody $1,000 because they didn't believe that was the right thing to do.
Mr. Chairman, to council, so I'm clear, because I want to make sure the board is clear on that testimony. Are you saying that that was improper or proper? That the underlying permit paid the $1,000 to not do the work? That's what I heard. Is that what
The
you just
understanding
stated?
was to pay for the permit and the work. But when the time came to do the work, he didn't want to do the work. So you have
Okay.
to go a different route.
Thank you. I just wanted to clarify that. Thank you for the board. Thank you, Mr. Chairman.
And just so it's clear, they just didn't think it was proper to pay somebody $1,000 to pull one permit. They thought something was weird going on and they wanted nothing to do with it. And once he decided not to pay that person, he pulled the permit, and that's when we believe that raised the issue and all the inspections came. Moving on to section number 3, the required sprinkler. We have the occupancy permit here. It is dated 4/2/2013, CO 130110043. It is the occupancy permit. It says special conditions, Cuyahoga Court of Common Pleas case, civil CV 02476634, BBS docket A-8612. Should legal access to the second means of egress expire, occupancy level must be adjusted or sprinklers added to comply with the current code. We believe the second means of egress is the picture that we've shown extensively, with not only 2 bollards, but now 4 bollards placed in there. And we also show them the title work. Did you ever find the date on it?
I know the whole history of this place. 1968, Lieutenant Waikey.
Thank you.
Caden Fire.
To the chair.
To the chair. 1968, it became a tavern.
Yeah.
From the business use.
And I think that one was dated prior to it even becoming a tavern, the easement. Is that correct?
The permit in 1968, they changed it to a tavern. I don't know about what he's submitted here.
Mr. Chairman, this is Patty. I'm not sure this is relevant, given there is a certificate of occupancy.
And so that's number 2. Number 3, we believe that they have a proper certificate of occupancy. We believe that the picture on the right has not changed. They've even went above and beyond and added a second set of bollards to make sure nobody could ever park there. So we believe that the case in common pleas, a judge has already ruled on this issue. So we would hope that number 3 would be found moot, or rule in our favor to say that, the second means of egress has not expired. Moving on to number 4, access to the public way. And if we could go back to the pictures they had showed, it says that they prevented the access.
Now, I got a question on 4, 5, and 6. And that this was put out here by fire, is that correct?
That's correct.
Okay. And shouldn't that have gone through Vanover's office for building?
Well, I believe in the 2024 building code does give a provision for fire prevention to assess the building code to where it conflicts with fire prevention.
Mr. Chairman, this is Patty to Captain Talbot. The city's building code?
The Ohio building code.
Mr. Chairman, 4, 5, and 6 cites the city's building code.
Lieutenant Waikich is chairman. The city has adopted the Ohio Building Code. Michael Crawler to.
Mr. Chairman, if fire could answer the board's question, should this have gone through Vanover's
Office.
office? Thank you. I couldn't remember what the word you used.
The easy ones I get. Yeah, I mean, and that is the question. Should this have gone through Mr. Vanover's office? But you're saying, you are making a statement, I think, that.
Yeah, well, through the chairman, to the chairman, could the chief building official opine on that issue?
Mr. Chairman, this is Patty. This is still a fire citation that fire has to demonstrate why and meet. There was objections in the appeal, and the board has asked fire to explain why they, Public Safety Division of Fire, cited these. So just to be clear, we do need fire's testimony.
Understood, but for clarification, if we could hear from the chief building official on that issue.
So, Lieutenant Wyke is the chair. So the building was opening and operating without a certificate of occupancy. That's why Cleveland Fire was contacted to go out there to see if there was a peril, and we demonstrated that peril through they have not maintained their means of egress. Your means of egress isn't just adding a door or some bollards at the door. Your means of egress is your exit access, the exit, and the exit discharge. They reconfigured the whole building. That's why they need a new certificate of occupancy. It's right in the Ohio Building Code. Section 111.3, the validity of a certificate of occupancy or certificate of completion. The approval is conditioned upon the building systems. Your egress is your system and equipment being maintained. It's not maintained. They took it all out, reconfigured the floor plan, and they haven't received a new certificate of occupancy. So the peril is you have the building.
That wasn't the peril, wasn't the question. Mr. Chairman,
Or that's why we're
council,
here.
council would like to respond, it sounds
Sure.
like.
Okay, go ahead.
No, I think that you board picked up what we were going to go to. We would hope that the 4, 5, and 6 would be, maybe at a later date. Mr. Vanover will most likely probably bring those, but hopefully we could address those issues in a proper way that the fire department does not have the right to bring those. We would like to, we could even walk the fire department through there and show them that they're incorrect about the passage ways through the egress. They've actually expanded on it. They've added stairways. They've added exit signs. All that. We do have a video. I don't know if the video is there. If we could play the video, maybe this will help them to see the video of the exit signs and how to get in and out a little bit more. But we believe that we should be able to be open up and we'll address Mr. Vanover's objections at a proper time and a proper forum. And we hope the board agrees with that and that we can maybe skip over 4, 5, and 6.
Well, that's.
Please, if you could play the video.
Mr. Chairman?
Before we go to videos, right, go
Okay.
ahead.
Can we?
Because we need to address 4, 5, and 6. So rather than see into it, and like you said, that may be brought up by Mr. Vanover at another time for sure. But that's the question. Okay. And to the board, do we feel that this was properly issued by fire?
Mr. Chairman, I'd like to back up one step. I'm a little bit confused. There's been a lot of testimony and I did not want to interrupt.
Oh, go ahead.
I'm understanding the testimony to say there were interior alterations to the stage, to the egress, to the mezzanine, to the stair, and all of that.
Yes.
I think I heard that those changes were permitted and approved through the city, but I don't know that I have that understanding completely.
That's our testimony, correct?
So that is the case.
Yes.
To the chair, I can't confirm that. I would like to hear again testimony from the chief.
Lieutenant Wyke is the chair.
Wait, you gotta tell me who's talking.
Lieutenant Wyke.
Okay.
So if you look at what was submitted and approved, that large purple seating apparatus that's on the raised platform was not on their plan.
All right.
Permission.
Or the stage seating. That all plays into your means of egress. You're creating an aisle access way then.
And I apologize for interrupting.
No, that's fine. I get it.
You hit the red button.
Yeah. So that creates aisle access ways that the plan reviewer needs to see. correct? And as far as the other issues, like 4, 5, and 6, the interior finishes, that absolutely plays into your means of egress. The smoke index, flame spread, all that is related to the time people have to get out of the building. That all needs to be submitted. On the drawings, it says it's going to be submitted by the owner. Did the owner ever submit that to the city?
Yes, it was submitted. This is Michael.
Hold on. Yes.
Finish.
It was, what was submitted was a report that says the carpet and couches comply. And then and they gave us a plan for the hood install. We're not looking for that. We're looking for a technical opinion report provided by an architect or a design professional. We're not looking for somebody to say the couches and carpet. They have more than couches and carpets in that building. They've added to their private viewing rooms. They've added curtains. I mean, I could go down the hall. I could just keep piling on. As far as now, you're not getting notification for that fire alarm. You don't have it anymore. You're behind a curtain in a private room. I mean,
I'm talking about on notice of any of these different things that he's citing. We've never heard of this.
Mr. Chairman,
these issues just keep
Patty, these are directly addressing 4, 5, and 6, which is what you were.
Yeah, which are the
questioning.
interior finishes which have been added, which weren't provided to the city. Now you've added that interior finish, which is that curtain.
4, 5, and 6.
Well, before you get to the merits of them, the board still has on they're asking why these should not be found. I forget what you said again.
Right.
Mr. Chairman, whether
It's
these.
filed by
Thank you.
Hanover's office. Exactly.
Thank you.
Yes.
Mr. Chairman, in my opinion, items 4, 5, and 6 would typically be the jurisdiction and citations issued by the building department, maybe with recommendations from the fire department. But what I think I'm understanding now is that there's a discrepancy between what was understood to be permitted, and what was built, and maybe an incomplete follow-up on some of that, on some of the details of the permit. That's what I think I'm hearing.
And was it inspected? Usually they do an inspection when it's done, and so they would have seen this.
I know we haven't had a chance to respond at all. I know you guys have kept going, but we would like a chance to
absolutely go
ahead. So if you could hit your.
To the chair, guys.
Yeah.
Mr. Chairman, the council would like to respond. The board, for procedural, Mr. Chairman runs the show. And procedural, he was asking the board's opinion on a couple of questions. And yes, everyone's going to get a chance to respond, but go through the chair and let the chair acknowledge you. Thank you. Sorry, Mr. Chairman, but council would like to respond.
Okay. I'll renew our request to respond.
Mr. Chairman, I also have a question.
All right, let me go to board member first, because I want Ms. Lipscomb to go ahead and speak.
Okay, so testimony, it has been testified that plans were drawn up by a licensed architectural firm and submitted in 2023 or 2024. Correct me if I'm wrong. They were permitted by the city. Work was done. And was a certificate of occupancy given at the end of work or not? That's my question.
State your name.
Name is Rose Tabron, owner of the building. So certificate of occupancy, that's right here. Right now, if you call the building department, they'll tell you that my certificate of occupancy is valid. From 2013, even when we
I'm not talking about 2013. I'm talking about the work that was recently done. The
Yes.
way it works is.
Yes.
Okay, so you have a certificate of occupancy?
Yeah, so we put an addendum on February 14th of 2025 that when we put that addendum in, that was stamped and approved, which allowed us to get the hood permit. We have that here as well to show you that not only do we get the plans approved in 23 before we worked, but we also have the addendum here that stamped from the building department on February 14th of 2025, a couple of weeks ago, that said that I do have a valid certificate of occupancy, and that's why I reopened that day, because they printed and gave it to me on February 14th.
Okay.
Mr. Chairman, Dan Jacobson from Law.
Go ahead, Dan.
Thank you, Mr. Chairman. The issues regarding the certificate of occupancy and permits, it's law's opinion that with the presence of the chief building official, he could add clarity to that. So I'd ask the chair for permission for the chief building official to speak on that issue of the status of the permits and the certificate of occupancy. Thank you.
Yes, yes. Go ahead, Mr. Vanover.
Mr. Chairman, a certificate of occupancy was issued and granted with variances in 2013. In 2023, a plan approval was submitted that included renovations in every part of the building practically. That plan that was submitted was reviewed and was approved, and construction began. Under the Ohio Building Code, section 111.3, when you remove the systems, including the exit access, the exit, make changes to the exit discharge, you change the exit travel distance, and you change the net floor space, you have removed those systems, and the validity of the previous certificate of occupancy, well, it's no longer valid. That's what the Ohio Building Code says. In essence, Mr. Chairman, this is a construction site. And once the work began and they removed all, and there's photographs, I know that the Division of Fire has been presented. Once the construction starts, the certificate of occupancy becomes invalid until a new certificate of occupancy is issued. My understanding for the issuance of the cease use is because they opened a bar, restaurant, club in a construction site. There have not been final inspections and as required by the code, and there has not been a new certificate of occupancy issued. So ultimately, the position of the building department and then in concert with fire, these hazards and all of the requirements are in place because it is currently a construction site that they are operating as a bar.
Mr. Chairman, this is Patty through the chairman to Mr. Vanover. Isn't that then through your own testimony, 4, 5, and 6 should be through you and not through this fire order?
No, it is not. The Ohio Building Code and the Ohio Administrative Code grants the Division of Fire, either the state fire marshal or the local fire official, the authority to enforce matters of fire prevention. And we believe that the items that are, and that is in the building code, granting them that authority, and it goes further to define fire prevention to include maintaining of the systems required for egress, the systems required for suppression and other fire prevention items.
And Mr. Chairman, as a follow-up, this is Patty to Mr. Vanover, and what, is that chapter 9? What chapter?
No, that is chapter 1. The administrative portion of the Ohio Building Code grants them that authority.
And so, Mr. Chairman, through Mr. Vanover, through chapter 1 as well of the Ohio Building Code, isn't that through an adjudication process?
It is through section 109 is the adjudication process for the building department issues, but the Ohio Fire Code, as referenced in the Ohio Building Code, also has its own adjudication process.
And Mr. Chairman, as a follow-up to that, to the fire officials, the Ohio Fire Code through ORC 3737.43 and OFC 108.1 does not give this board authority to hear a state fire code. Isn't that correct? To the fire official, you presume your CFSIs?
Yes.
And Mr. Chairman, I just want to make the record clear that's through the city's own testimony, because what's cited is not chapter 1. What is cited is 3111.01 of the city's building code.
Lieutenant, what do you chair?
May the board respond to Mr. Vanover's eloquent rebuttal? He's trying to usurp the judicial process. There has already been a court order on this. We've had 3 hearings on this. The court has ruled that this occupancy permit is valid and that it should be. They did not make substantial changes, and that's not why we're here today. They were told they have a valid occupancy permit. This is the first time that anybody's saying they don't have a valid occupancy permit. We have testimony from the owner that just 2 weeks ago, he was told he had a valid occupancy permit and one was put in his hand. This is all new stuff that we have not had a chance to rebut. We have a judicial order from the court requiring them to issue a certificate of occupancy because they've tried this before to close this club down. And what they're doing is not right. They might not like the type of people or the type of entertainment.
Mr. Chairman, this is Patty, but this is just, Mr. Chairman, this is Patty. Chairman, this is Patty. There's no, I don't think we should be ascribing any ill intent during enforcement of cities' codes, especially city safety codes. By the certificate of occupancy from 20, whatever, it referenced this board's prior docket 86-12 that I believe appellant is arguing to this board that they are in compliance with. Is that correct, Mr. Chairman, to the appellant? And Mr. Chairman, to the appellant, have you read the be it resolved? What is the conditions of A 86-12 that is incorporated in the certificate of occupancy? To the appellant from through the chair. Has anybody read docket A 86-12 on the conditions from the appellant?
I think that's to the attorney.
It's to any of the appellant.
Okay.
Mr. Chairman, since nobody is going to read it, I will say this board can take judicial notice of its own docket in A 86-12. The final be it resolved that the ruling of the board is to grant the variance required for the main front door swing, comma, noting that the front door swing in the wrong direction is locked open during all periods of occupancy, comma, and to grant the variance for accessibility of the second means of egress, provided that there is an easement or legal agreement to maintain the opening at the second door to the main parking lot, comma, clear during all seasons, comma, and to waive the recording requirement per the agreement, semicolon. Should the conditions change, comma, the occupancy level must be adjusted or sprinklers added to comply with the current code, period. That is what this board ruled, held in the docket, and that was what was incorporated into the certificate of occupancy.
Lieutenant Wakey to the chair. That was under Lieutenant Wakey, Queen
Okay,
Fire.
go ahead, Lieutenant.
Yeah, that variance was granted under those conditions that were present at that time. The conditions have changed. Right? They did
Sorry.
No, I'll let you speak. So the conditions have changed. They pulled a demo permit and they made interior alterations to the most important thing of any safety feature in a building, the means of egress. And that's where the peril is. It's not that they keep a door open or unlocked or they put some code. You have to maintain a means of egress the whole way, the exit access, the exit discharge. That ruling, that variance was under those conditions that were present at that time. The conditions have changed. They pulled a permit to change the conditions. That's what we're talking about here.
And I believe our testimony was that the door was widened from 36 to 86, and the architect would like to give testimony, and I believe he already has it. It did not affect the egress. The plans were submitted, and I have them here. You talked about them not being part of it. They did have their plans submitted. I'll let the architect go ahead and testify to it instead of me testifying to it. Go ahead. Say your name.
We submitted these plans, and my name is Racine Parker. What she just mentioned was the variance for the occupancy had certain conditions, and we have not violated those conditions. We actually improved them by improving and widening the door, which would improve the situation with the variance, as well as any exiting is still maintained to be at code. There's according to table 2-1017, 200 feet in an assembly space is still maintained within that space. So exiting has not been negatively impacted by any of the construction that is going on, any of the changes that have been made. And the peril that they mentioned, the stairs, there are stairs right at the bottom of those stairs. You do not have to transgress the whole stage. You can walk right at the bottom of those stairs. There's another set of stairs that you can transverse right down.
Picture you're pointing at, please.
To the third one at the top. There's still stairs on each side of the stairs, right at the bottom of those stairs, which maintains egress from the mezzanine. The mezzanines have not been changed. The egress from each mezzanine is still the same, according to the variance that was issued 2012. So any changes to this space actually improves the conditions of the variance. The peril mentioned is not. I don't understand where the peril comes in. We can address any materials at a later date. We can address that and show improved. They're safe, and if they're not safe, we can change that with the materials. But the exiting is maintained. The stage being moved to the middle or whatever the configuration has changed has not created an additional peril other than what was present at the original variance.
I think that's
Mr.
with the
Chairman,
board.
if this is Patty, if they could play they want a video and they have the right to present their evidence to this board, if they can play their video.
Okay, and just before you do, because I think the board wants to understand also that this is the same layout that was in there at the time, because I mean, that's what it comes down to, the egress, okay? If things changed, we would like to know if it has, he did show one in that going back to the back door where there was some kind of an equipment there that was installed since then that could be a hazard. And I know that I think that it was pointed out by fire. And it's in that door here on your lower left, that stuff that's in there. There's some stuff that, and this would be right in, you're going to go out, exit. Is that part of that exit?
Yeah.
No, Willis Tabor, owner of 620. Are you talking about the bottom left picture, the bottom two left pictures?
Bottom left. The bottom
Yes,
left.
that's on the second mezzanine. They're confusing the mezzanines. That's the mezzanine that only allows 26 people. That's on the south side. That's on the front of the building. There's two mezzanines.
Okay, this isn't the way out, right? This is
Dave Talbot to the chair. These are my pictures. Can I explain them?
Can I? Which picture are you talking about? The one on the left?
No,
The one
lower left. The lower left.
The lower left.
Yeah.
That's a pass through.
Oh, that's the pass through. Oh, that's the pass through under the stairs. I'm sorry about that. Yes, you can walk through it. And I also have a video of me.
If we can clear, that's pivotal to what he's asking. Let him go first and then the fire department should respond. But that is what Mr. Chairman is asking specifically. Don't brush it off. It's important to him.
Okay, so now I understand the question. You can walk through from the east side of the building and get to the west side of the building through that pass through. There is a passageway, whether you're on the west or the east, to get on either side of the building. We did not take the stage all the way to the wall. You do not have to climb over the stage in order to get to the other side of the building. And I have a video of me walking through the entire building as far as the easement, so that way we can see it clearly.
And Rossing Parker, the reality is that is an extra precaution for exiting. The current front door, the people on the east side, sitting on the east side of the stage can go exit through the front door, no problem. The code. The people on the west side of the stage can go out through the parking lot door. So this door that they're mentioning as a hazard isn't really a critical part of the exit passageway. It's an additional opportunity for employees to maybe exit out through, but it's not a requirement, or is it part of the traditional exiting requirements for the public in that space?
Maybe we need to see the video of how everybody's passing through here. So if you have that, maybe if you look at that, it'll clarify some things. So we'll go ahead and run that video.
She's doing it. It's a little bit of a delay, Mr. Chairman. Thank you.
Yeah, no problem. And then fire can respond and, we can. All right, there's the video here, right?
Since there is no audio, can he go ahead and narrate?
No.
Yes.
I said, I made the door, this is Willis Tabron, the owner, made the door wider so you can be able to come in. So now that it's wheelchair accessible. When I pointed to the ground, I was just showing what the city made me do to make sure that it is handicap accessible. Wider lobby, so that way it's actually improved the easement. Now I'm walking in now, and you see that big walkway? You can get right through with no issue.
48 inches.
It's 48 inches, which is code. And now he's showing the entire building, the stage, which if you walk all the way down the stage in the front there, you're gonna see there's another walkway. So there's actually 3 ways to get up on the stage. And now it's showing the men's bathroom, women's bathroom, which the building always had. And I'm walking through, which that's wheelchair accessible with no problem at all. You see those stairs right there? Those are the white stairs that they're saying that I do not have. So that's the second stair, and I also have another one that's on the other side as well. So those are the main stairs right there that came with the building. Now I'm going to walk outside in case of a fire or anything. See how I just walk right through? He's following me right out. This is the exit strategy. Those doors right there are just swinging doors. You can't lock them or anything. You can walk right through them. He's going to show the kitchen, showing that the hood is shut down, showing that we did fix the hood. So he showed the kitchen. This is the original door. That's the exit sign. I'm going to walk right outside. No issues at all. That's the second door of easement. Those are the ballards. Egress, sorry about that. Those are the 4 ballards. Those 2 right there, it was originally 2 when I got the building. They added another 2 September of 2024 to comply with the agreement that was set up. Now I'm walking down just to show you, because of the adjacent building behind me, they also have a walkway that the parking lot does not block. And that's what I'm showing you right here. Do you see that? That's the law farm that's right behind me. They have a walkway for them. So for me, they put ballards. For them, they spray painted on the ground.
Is there any questions about the video?
I don't have any.
That's very helpful.
Lieutenant, like if the chair, if I could comment on the video.
Yes.
Sure, he's showing one person occupying a large room, right? Sure, you can get out of there, no problem. What happens when that place is filled with people? I'd like to go back to where he says you can come off of his exit from that mezzanine level down the exit access stairs to the stage. If you could bring up our pictures again. So the bottom left picture shows those steps. Are those steps permanently affixed? They don't look permanently affixed to that stage in that photo. The bottom left picture shows the top tread. Or the bottom right. And if you look at that tread width, the reason it's so narrow is because they know if they make that to code, you're coming out into that exit access aisleway. I mean, they're not permanently affixed there.
Go ahead, respond then.
This is Michael Carvalho, MEK Construction. Work was stopped. You guys wouldn't let us do any more work, so we couldn't finish those stairs.
Well, that's what we're saying. They don't occupy until the work is done. If I can continue on,
Those stairs are 36 inches wide.
So we're not debating whether he widened the door. That's great. 49 people. If you want over 49 people, you have to have a second exit, right? So how do you get to that second exit? They mentioned 200-foot travel path.
And you go up the spiral
Yeah,
stairs.
well, the common path of travel You know, it's what, 30 feet for an unsprinkled assembly? So if I'm in that back corner,
Which is less than 30 feet to the side door.
To-
The
to-
building
no,
only
to-
35
you
feet
can't get to
wide.
the side door.
Mr. Chairman, to the parties in the room, you didn't like when they were interrupting. Let him do the same. As I'm trying to be fair to both parties.
Mr. Chair, to the appellant, I'm not here to prevent this place from ever opening. That statement was made in the beginning. I'm a 49-year resident of the city of Cleveland, which is predominantly African-American. I went back to the occupancy after doing the fire alarm inspection, and I talked to the contractor regarding that hood. I went back on my own and looked in the cellar to see if he needed to pull a permit. I didn't have to do that. So when they make accusations that we're trying to prevent this place from opening, I take offense to that. I went above and beyond. And again, as somebody that's lived in the city of Cleveland for 49 years.
Mr. Chairman.
So we'll go back to the video. All right. I just wanted to clear that up.
Okay.
So back to the video. When the chairman pointed that out, when you go underneath those mezzanine steps, you got equipment there. You have to maintain a continuity throughout your egress travel. You can't go past equipment like that. When you finally get to the exit discharge, which is at that side door, they have all that equipment there, those freezers. Somebody opens that freezer door, it protrudes into your exit access, right? Your common path of travel. You can't, hold on, I'm not finished yet. And then when you do, they added bollards, again, to the outside. Okay, how do I get to the public way? They're responsible for getting into the public way, not just dumping one. He shows one person walking out. They're at 100, say they want 150, right? So 75 people are going to come barreling out that side door in the event of emergency. Where do they go? Right into the direct path of the circulation of cars. There are provisions in the code to address that. Are they addressing that? 1028.5.
Hold on.
So that's why we're saying there's peril here. They haven't addressed any of that.
This is the chairman. I want to, all these conditions, I believe, existed when they okayed it. Okay, as far as going out into that back and however it was, that was all okay. That's been taken care of. That's been approved, and it was approved to be able to do this.
It hasn't been maintained, sorry, Chairman. Has it been maintained?
Unless, well, that's the question. Is there something different about this than when it was approved? And I guess that's it has been improved going out the front. Going out the back, I think believe it may be the same. So I don't know whether we have anything here that's different than when it was originally approved. And to say now, well, we don't like that they approved it last time. It shouldn't have been that way. I don't know if that's right or not. But that's one of the
Mr. Chair, this is Patty.
Yeah.
Are you making a finding as to the locked open swing door?
Are you testifying?
I'm asking, who asked me if I'm testifying?
Me. I mean,
Mr. Chairman and Mr. Vanover, as I'm representing the board, I am allowed to point out things to the board and ask. I believe Mr. Vanover is objecting to me asking based upon my question to you. So you can rule, I guess, on his objection.
No, I want to hear what you have to say.
I just was asking based upon the board's A8612 variance. You were saying that you believe that things had not been changed. I was asking if you were making findings as to the specific testimony that was provided as to the front swing door.
Well, the front swing door, I believe, is better than what it was. I mean, when he showed it in the video, I mean, that's a huge opening, and it's swinging out. It's not swinging in. So a finding as far as that being bad, no, I think that's good.
No, not bad or good, just whether it's been changed.
Yeah, they said it was changed. They said they made it bigger. Yeah, no question. It has been changed, but again, that's not like putting stuff in the middle of the way on the egress. That's changed for the good. But yeah, it's been changed. There's no question, and they admit that. When as a board, we're trying to figure out what's changed in stock to make this different. And if there's something that maybe I would say if Vanover's office wants to put something out there and taking a look at it, as far as this egress and all that goes on, and Vanover did say that they don't have an occupancy permit. Is that correct? And they're saying they do. So there's a whole difference here in whether they do or they don't. It's just Vanover has said it's a construction site. You know, it's not, and so and they're saying no, it's approved. So that's a big difference between the two.
Mr. Chairman, Dan Jacobson from the Law Department. I was given testimony about the current status, the state of the safety of the building. The appellant has given testimony that the permits are still in place. They haven't finished work. With the status of the building permits and the chief building official here, I would like testimony from the chief building official regarding the status of the building permits and the current state of the project as a whole.
May I intervene? Willis.
1 second, let the chairman answer.
Okay.
Dan Jacobson, and then he will.
Okay. Thank you, ma'am. Thank you.
Okay, Mr. Vanover.
So, excuse me. So, Mr. Chairman, to that point, there was a plan approval issued based on the information that was provided in the plans. There was, and work began. I will state again, there has been no final inspection on the project. And so therefore, it's currently a construction site until it receives final inspection, final certificate of occupancy. The appellate has stated that there were no changes that would require a change to the occupancy. The position of the city after inspection, which the code provides for that, we review plans, we approve plans according to what is submitted, but upon inspection, we verify that what was submitted and what is in the building is the same. That there has been significant changes to the egress paths, the travel distance, and the design professional states that those all meet code. However, none of that was presented in their plans for us to verify. I would like to speak on the previous certificate of occupancy and just some misinformation that was provided regarding that document. There was a court case, and we've heard that it was heard 3 times. The substance of that court case was surrounding the adult entertainment portion of the building. Nothing in this order from fire or from any other order has denied them their right to conduct adult entertainment at this location. That was settled by the court. That's a matter of case law. Nobody has disputed that. However, it is inconsistent with the law and inconsistent with the administrative code and logic to think that one can go in, do a complete remodel of a building, and then just continue to operate throughout that process without receiving final inspections and final approval. The certificate of occupancy, and understand that the expectation is that they maintain their 419 person occupant load. And the previous certificate of occupancy was issued based on conditions at that time, which included net floor space so that one can calculate the occupant load out of Chapter 10 of the building code, travel distance, egress widths, all of those things. It is not logical and is contrary to the code to think that all of those things can change without a change to the occupant load. However, there's been no order from the building department stating that the second means of egress that the variance doesn't carry. Right, as the Ohio Building Code and the Administrative Code, the existing building code, both provide for existing conditions to the extent of the alteration that will allow for the existing conditions to remain. As a bar, adult entertainment bar club, The variants, to the extent that they're unchanged, get to remain. However, the interior occupant load, travel distance, and the complete removal of a compliant stair, those things do not get to carry once they're changed. It's illogical to think that there's a certificate of occupancy issued and then a total reconfiguration of the space and all of those things get to remain. And just in closing, our position is that it is currently a construction site. They have to account for changes to the occupant load, changes to the travel distance and common path of travel. Working within the variances granted, and that as a construction site that has not had final inspections from the Division of Fire and the Department of Building and Housing, that the occupancy and use and conducting business in this space is contrary to the codes and is a peril, as it would be if any other construction site that just continued to operate while they were under construction and after they've removed the egress systems and changed the components inside.
Yeah, board member, if I may respond to that, that's very nice. He did send us out a notice of all of these points about 24 hours ago. We were sent an email that would not be addressed today. And none of those are the table. He keeps calling it a construction site because it's a colorful term. You know, anytime anybody gets a permit to change anything, are we going to call it a construction site? And to stop use because it's, you know, they decide to make the door wider. It seems like that would be against what the city would want. It seems like you would want them to make it easier for people to get out of the building. They made the doors wider. They're saying that they've given testimony and shown a video that you can come up and over the stage and that you can go behind it. There was a picture there that was blurry. I could not see whether there was stuff blocking that path in that picture. They've given testimony that there was not. And they keep calling it a construction site is fine, but you know, they do admit that they didn't, their hood permit was improper where they thought it was. That is the final thing. We believe that Bob Barr, that he sent me a little note that he's ready to provide the final inspection for the hood. And that's it. So yeah, that's true. The final hood inspection did not go through and that's not done. But they have made this place safer for the public. They've added handicap accessible where it wasn't. You know, they took out the curb and put in a ramp. And they had this other one, and he's right. That one case was about adult entertainment, and then they tried again about the doors, and then they're just trying to skin the cat in a different way this time to try to say, well, now because we don't believe the egress is proper, which we have shown it is, we're going to completely shut you down. And you know you got to come in and testify within a week to all of this. We have the architect here who says it's up to code. We don't believe section 4, 5, and 6 are applicable today, and so that would really only leave 2 and 3 that we'd like the board to rule on. And we believe we've made the points to, you know, that the place should be able to stay open and there's not a peril. If anybody else, the architect or the construction person would like to speak on whether it's a construction site, because you've done numerous construction. If you could say this is a construction site, that means it needs to be shut down, or if it's a construction site where you can continue operations.
This is Michael Corral, MEK Construction, the general contractor. It is not a construction site. The only part that's being worked on right now is the hood, which they requested we get permits for, and we did get permits for. And I also did, if you could hand me that, get final inspections on electrical, plumbing, and my fire panel that was installed there. Mr. Bauer was ready to sign off on my final, provided fire came in and inspected the hood, which I will have a hood inspection either today or tomorrow.
So, Mr. Chairman, that was, if I can just speak to that specifically, the Inspector Bauer was reviewing based on the occupant load of 150, which is what the approved plans at that time concluded.
After the addendum change?
No, I didn't even say when Inspector Bauer was on site, it was for 150%.
And I also spoke to him after the addendum change that we submitted that corrected the occupancy
To 417.
to 417.
417. So,
And he was still on board.
Mr. Chairman, if I may ask, I think what is, and I'm
Mr.
expecting.
Brown was the inspector on the whole
Yes,
job.
I'm expecting that perhaps, so, and I'll just to move on, Mr. Chairman, the concept, the comment, that construction site is just a pretty term or whatever was used. There was the entire stage, that long platform stage was constructed as part of this, right? And so it was built and reducing, this used to be a dance floor here, and the stage was approximately 100 square foot stage pushed up against the wall. So this commentary that it was just decorations and adding is incorrect. There's photographs of the construction of this wood frame stage through the middle of the bar, reducing the net occupant load. It's not a matter of we want to pull the certificate of occupancy. The Ohio Administrative Code says that when you change the interior egress paths, when you change the net occupant load, previous certificate of occupancy becomes invalid. This was not information that was provided. There's no occupant counts. There's no travel distance paths or no life safety plan in these drawings. And there were also no plans of what used to be there. It's only under, which allowed by code, it's only under inspection that it was identified that this wasn't changing some walls and re-drywalling some portions. It was an entire reconfiguration of all of the interior space. So this is not a pretty term. This is the law. I recommend the design professional and counsel actually read the administrative chapter of the
Mr.
building
Chairman,
code,
if I
because
may.
this is, I'm not just making up pretty terms. The code says this.
Mr. Chairman, this is Patty. If I may, for clarification for the board's file, the appeal was made by Mr. Tabron, who stated that he owns the property, but the records indicate that the property, because in his own appeal states that the owner is Frankfurt and Six LLC. Can Mr. Tabron explain who he is to the property and to the LLC to make sure we're properly here before this matter?
If we may first, can we go ahead over Mr. Vanover's thing? These plans were approved in 2023.
Mr. Chairman, this is Patty. This is a legal requirement for proper jurisdiction before this board. I'll restate my question because this is for the board's records to make sure the record is clear for the board. I'm going to restate the question now. The public records indicate, as well as through the filing, that the property owner information is Frankfurt and Sixth LLC. Applicant is Willis Tabron. On the notice, he's identified as statutory agent, which does indicate that under filings, state filings. The board can take notice of that. However, this board requires LLCs and entity owners to have agency statements from the LLC to proceed on this matter. We kind of jumped right in and going through my notes of the issues for the board's record. If there can be a statement as to who Mr. Tabron is to the property and to Frankfurt and Six LLC so that we have proper jurisdiction before this board. Thank you.
So we need to be sent in.
Just say who he is to the property and that he's properly before this board, just like everybody else does to you.
And allowed to speak, yes.
All right, Frankfurt and Six, I am the statutory agent of Frankfurt and Six, which owns the property. I am Willis Tabron, owner of the property.
Mr. Chairman, my question was, who is Mr. Tabron to Frankfurt and Six LLC? This board requires a statement from an entity owner saying that this individual has the right to proceed before this board. As this practice before this board, if he does not have one, I would defer to Ms. Davis whether the board's file has one. He has to obtain one from an officer of the LLC so that the board, a notarized, I think she says it's a notarized requirement, before this board, which this board regularly allows to be presented before the board adopts it. Otherwise, we have a jurisdictional problem before this board. Thank you.
You understand that?
Yes, yes.
Okay.
I am an officer of the LLC.
Mr.
Okay.
Chairman, to Mr. Tabron, what officer are you? What's your position with the LLC, which is what I've been trying to ask you to state?
Yes, I'm the owner of the LLC.
You're the owner,
Yes.
okay?
It's a limited liability company, Mr. Chairman. Are you the president? Are you the secretary? Are you the treasurer?
Yes. I am the president, yes.
Thank you.
Okay, so does he still need something or does that take care of it?
I would defer to this board. Usually he usually signs as president of it. There was no indication to that. He's given sworn testimony to that to this board. You can find, that's up to you to find that that's sufficient or not, Mr. Chairman. Thank you. It was sworn testimony.
All right, we will find that. Unless there's an objection from anybody on the board, we'll find that his being the president is sufficient.
I don't object.
Okay.
What I wanted to state was, as far as I've been dealing with, I purchased this building in 2019, and when you go to the building department, everybody has a policy. And I poured a lot of permits, hood, electrical, plumbing, upgraded those systems, upgraded the fire alarm system, because I just wanted to upgrade things. As far as when you go to the building department, correct me if I'm wrong, when you go to the building department, there's a permit that requires you to file for a new occupancy. I didn't file it. I didn't change the square footage of the building. It's impossible because I'm between a parking lot and another building. I didn't change the use of the building. The square footage is still the same. If you look on the diagram that's up right now, you see the 2 stages that were approved. All of that is now a means of egress to get out. If you look at those sections, you can go from left or right from the top. If you look at the bottom right below, the people that sits below, they all can exit. That's all space now. They're trying to say that that stage takes away the easement, and it doesn't, because the whole easement egress, because the whole left side is all egress. The little circles that's on the bottom, they can all exit. The stage that's up top, that's all egress now. Those are all pathways to get out of the building carefully.
It's all still part of the square footage.
And there's also a part of the square footage as well.
But there was significant changes inside the building with the staging, in that it's going down the center. I mean, I'm not here to say that it's less or more or whatever, but they are significant changes. I don't know how that affects, it is what you were granted in the beginning. To allow this not to have a sprinkler system, and so I'm not sure how that's affected, but I think we are going to need a final inspection on all of the work that was done, and so that's something that has to be. And then once that's done, then the determination could be made if it's considered to be changed enough or not.
What I wanted to say, Your Honor, was if you look at it, we're basically here because of the floor space, and that's actually those 2 stages where they're sitting. That's all floor space. The stage, that's all a part of the square footage. That's floor space. So everywhere they're sitting, they can walk with no one in their way on top of the stages that were approved. They can walk out of there, and the people that's sitting right below them can walk out of there. Everyone has a path of egress in case of an emergency. They all have their pathways. Now it's just like it's more structure. Everyone can go north or south in order to get out of the building.
If I may I ask the board then to make a ruling that, that they keep the kitchen closed until that inspection happens, and that they be allowed to be open as they have been occupied, and, you know, they were never told that during any of these approvals that it was a construction site that had to require a closure. They operated during the construction period, and we asked that they be allowed to continue to operate, and they will agree to keep the kitchen closed until that final inspection is performed with the hood. And then we asked that maybe make a ruling that number 4, 5, and 6 are not proper. Thank you.
And Mr. Chairman, before you issue a ruling, I would like fire to offer a rebuttal regarding that egress path and the image that was of the current status of the building, the ground floor, that Mr. Tabron was talking about during his previous testimony about how the path was applicable.
Yes, he can, I mean, and even no matter what he says on it, is that it naturally, he feels because of the changes that it's not proper. I think we know that, but, you know, and it's gonna come down to maybe having to come up with the square footage going out as to how much that's been changed, or the path itself, that it makes a difference as to what they've done. And that, I guess that has to be decided, but, I mean, I can let him talk on it, but I think I know what his stance is gonna be. It's been changed, you know, and it has been changed. And the question is, does it affect that decision that was made back then? And it's difficult for us sitting here to say, yeah, it's okay now, or it's not. I don't, the other board members, you have anything to say on that?
Yes, I do.
Okay.
I keep going back to the board's resolution from 2013 that allowed occupancy of the building as built, proposed use, all that everything was fine, except that the condition being that should, you know, quote, should the conditions change, the occupancy level must be adjusted or sprinklers added to comply with the current code. It's evident that conditions have changed. When the building permit, the current building permit was approved, it seems that the drawings did not describe the changes that actually happened, and those changes were uncovered when fire inspected recently. It seems to me that that's where the problems arise. The discussion that we're having comes from the fact that construction happened that essentially wasn't documented correctly and wasn't permitted, but because it wasn't documented thoroughly. And I believe that the adjudication order that was adopted in 2013 is no longer valid because conditions have changed, as it says in the adjudication order. Should conditions change, this all has to be reevaluated. And I believe fire is correct in objecting because proper documentation was never reviewed by the city.
Can I make a statement?
Yes.
Mr. Chairman, to Ms. Lipscomb, do you mean the board's prior resolution, not adjudication order? Is that what you're referencing? Thank you. Just for clarity.
I'm referencing from, you know, docket A 8612. It says the resolution. Yes.
Real quick, I'm looking at the occupancy, Racine Parker, and it says the special conditions are, should legal access to second means of egress expire? And that is the condition. I mean, that condition hasn't been changed.
That's correct. It was all about the second egress was the whole point. It had nothing to do with the interior of the building. It was the conditions that changed concerning the hazards of the door. Where I think what you would hope that they would change for the better is they did say they changed, but this isn't a change that we believe that would negatively impact it. If you go ahead and read through it, it doesn't talk about the interior and such.
Mr. Chairman, to council, but you're reading from the certificate of occupancy that also references the 2002 court case and this board's prior variance, correct?
Correct.
So, Mr. Chairman, to the appellant, why wouldn't all of those conditions apply? You're arguing the court case and the special condition, but not 8612? Is that what you're arguing to this board?
We're arguing that the certificate of occupancy is concerning the door and making sure that it was safe for people to get out.
Mr. Chairman, I think that legally that, oh boy. So, Mr. Chairman, to appellant, are you arguing that all of those other conditions don't apply to a certificate of occupancy issued correctly under Ohio law?
I'm not sure I understand your question. I believe that they have
Okay,
it.
I'll lay it out for you. You just argued that it's only one specific issue under the special conditions listed on the certificate of occupancy from 2013. That's at issue, correct?
Correct.
That's what you're arguing to the board.
So I could read the certificate of occupancy. We are reading that we believe that the change that they had talked about.
Okay, so Mr. Chairman, the council has certificate of occupancy CO 13, whatever the number is in front of him. If you can go ahead and read the special conditions paragraph.
Correct. And it'd be the one I've read before, so I'll skip the Coyote court cases.
No, that's the point, Mr. Chairman. That
You
you have to read the entire.
and I had read it to the record already.
Okay, so we're clear. The entirety of that is a special condition. Under Ohio law, that's really clear. You're gonna have Mr. Vanover go off here.
Mr. Chairman, if I could just make a quick point.
Go
Is
ahead.
actually, the council's statement, and the appellate statement is exactly the point. There's been, and they can't have it both ways. They can't say that the only conditions that are pertinent are the doors and the second egress, and then at the same time say that the court and everybody has ruled that this certificate of occupancy, regardless of anything that happens ever, gets to be maintained, because you can't have it. You can't argue both things. If I can finish, please. If I can, as we've stated, that the variances that exist remain to the extent of the alteration as is required by the Ohio existing building code, and all of the other changes that are done on an existing building that are required under Chapter 5 of the OEBC to conform with new construction, they do not. And they were not approved as new construction, as a removal, because the information of the existing conditions didn't exist. Our point is that it is more than just the kitchen. There has not been approval of the travel distance of the egress, so there's not been final inspections. You have an entire mezzanine that exits onto a performance stage, which is prohibited. And my position as building official, and I will let fire present their position, is that until final inspections and approvals are granted, allowing an incomplete construction of this renovation to allow for patrons to enter at 419 is a peril, it is unsafe, and is an imminent hazard.
And there's a possibility here, without getting into more, because we have heard a lot, and I think the board has something in mind as far as, what they know about the changes, what we've seen here, and the changes and how it affects what has been approved in the past, and what's been said about it. But I think that the exiting down onto the stage, if that's a different thing that happened, then of course I think there, and what I'm trying to figure out is that, is there a way for them to be open but only not at the 400 level. Because that's too many, and maybe that upstairs part might have to be eliminated until they get the changes or get approval for how this is going to move forward. But and I don't know if the board has, Mr. Dank, you got something in mind?
I think I do, and I think it's pretty clear. There's been some conflicting testimony, contradictory, and some subjective testimony. And to me, this all kind of boils down to evaluating whatever changes were made to assure that they comply with the egress requirements of the building code, travel distances and egress pathways that are free and clear. Personally, I don't know that the west egress, not into a public right-of-way, has been previously approved and would continue to be approved, provided the egress from the space is proper to that exit. So it sounds to me like it's a matter of providing a final inspection that is either consistent with the plans that were submitted and approved, or citing differences that were built in the field and are at a variance with that, at an odds with that, and correcting those conditions, but then just literally adhering to the black and white requirements of the egress requirements of the Ohio Building Code.
Okay, so what we're looking at is that it's going to remain closed until there's a final inspection.
I regret doing that because I don't want to inhibit people's ability to make a living. But if conditions were built that weren't consistent with what was submitted, then that would be proper. That would be typical for any project and any construction.
May I say anything? Say something on, and I don't know if it's in the exhibit. It should be, but on February 14th, when we realized that on the actual blueprints that the occupancy was wrong, we made an addendum on February 14th when we got the cease and desist. And on that addendum, this went to Martin Reese. They had to approve everything. So before we can even get to HUD, this had to be addressed. On this addendum, it says the construction drawings previously submitted listed an occupant load that was incorrect, whether from oversight or typographical error. It was previously listed as having a total of 150 occupants. This number is drastically lower than was previously listed for the same occupancy use and what's allowable for the occupancy classification assembly A-2. Also, as an existing building, alterations were made to some building systems and some furnishings have been changed. The emergency egress has been altered and the building square footage has remained the same. We will submit to correct the occupant load to match the previously approved occupancy, which is ground floor 342, north mezzanine 49, south mezzanine 26. Also, the interior finishes are installed according to Chapter 8 of the Building Code. Attached to the addendum are specification sheets for the interior finishes in question, particularly the carpet and bench seats. This was stamped and approved by the building department. What date? February 14th, 2025.
Mr. Chairman, this is Patty. You've heard all that testimony previously, but if so that has been submitted to this board.
But I did not have a chance.
The building department has to review matters before they can come before this board. So I believe that the appeal, that testimony deals with matters not currently appealed to this board. And so before this board is the fire order with those 6 items, which is dated February 13th. He's talking about, based upon getting this, they took a subsequent action. So what is before this board, you should be ruling on this appeal. You've testified 2 or 3 times to that.
A part of that appeal was, a reason why I read that, because that's answering number 2, which is the HUD.
You've testified to that.
Okay.
Right.
So So, Mr. Chairman, I'm trying to encapsulate for you what you've received testimony from both sides. You all have hit the nails on the head of what the issues are before you. I believe council has asked that you rule on 2 and 3 and has asked that you dismiss 4, 5, and 6, if I'm stating that correctly, on the appeal. And you have talked amongst yourselves on any conditions you might want to add on that, but I think that's what's before this board right now.
Well, that is, but again, the issue is that I guess they're asking that we lift the that it's been closed, and I don't think that the board members want to do that. I think they want to get a final inspection on what has been done, and before that issue comes up. So I think that it's if I was to craft a motion, it would be to that it remains that we're upholding the notice and that it remains closed until a final inspection. At that time, I guess they could resubmit in again as to whether they need to change what they need to change as far as having to install sprinkler systems, or whether the old we can go back to that and say, okay, it's adequate.
Thank you, Mr. Chairman. If that's your proposed motion, if you're going to have a second before, I'd like to have a discussion on whether or not you're upholding the entire notice or all items or just specific items. Thank you.
Okay.
Clarity for your record for this, for the resolution. Thank you.
Okay. We get a second.
Mr. Chairman, if we stay within the bounds of the fire department citation, that really deals with the demand for automatic sprinklers being installed and the hood, and the controversy over who has jurisdiction on items 4, 5, and 6. So while I have in mind the course of action that's appropriate to this situation, I don't know that my thoughts were further reaching than this fire department citation.
Why don't you go ahead and try it?
I can make a motion that the kitchen stay inoperative until the hood is repaired, as cited in the fire department's item number 2. I don't find cause to deem automatic sprinklers necessarily to be added, and I do find that items 4, 5, and 6 are more appropriately handled as recommendations from the fire department to the building department and processed further by the building department.
There a second?
I'll second.
Okay. Second, motion by Mr. Denk, second by Ms. Lipscomb.
I'm sorry, Mr. Bradley? Yes. Mr. Dink?
Yes.
Ms. Lipscomb?
Yes.
Mr. Gallagher?
Yes. Okay, notice will be sent out within 2 weeks.
Patty?
Thank
If I can have clarification, I just think it is, as long as they keep the kitchen closed, they're allowed to stay open at this point.
Yes, that was what the motion was, that they can continue.
Thank you very much, everybody.
Okay. All right, is there, we do have more.
Yeah, we have to go back to docket 18124. Give me 1 second, Mr. Chairman. Were they here? Oh, she came. That's who came in. She wasn't here when we started, though, right? Oh, she was? I don't understand. Oh.
Thank you. Yeah, thank you for your time.
Gentlemen, we have another docket. We have another docket.
Okay, are they there? Are they here?
Councilwoman Gray. Hey, guys, we're still on the record.
Mr. Chairman, Councilwoman Gray told us we can proceed. She would not be able to attend as she thought she would earlier.
Is this is for 181-24?
That is correct.
Okay, we can open it.
Yes.
Okay.
I have it up on the screen.
Okay, all right. Housing docket A 181-24, 3664 East 108th Street.
Application and fees are in order. Notice of violation is condemnation of the main structure issued on July 9th of 2024. Appeal was received on October 3rd of 2024, requesting for 6 months to complete abatement of the violations. Present for today's hearing, Chief Billing Official Tom Vanover, Dan Jacobson, Law. Will the applicant or his or her attorney and/or representative please state your name for the record? Mr. Gallagher, I do not see a representative of American Heritage in the participants panel, nor is that person present in room 514 today.
Okay, well, then we're gonna have to go over to Mr. Vanover. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth? Is he muted?
Oh, he stepped out.
Oh, okay.
Damn, I don't have him out here. You want to argue that no, he's present to uphold it.
Mr. Chairman,
Yes.
Dan from Law. Law does not have a witness, but Law would argue that the violation notice was accurately issued, was properly issued, and that the appeal should be denied and remanded back to Building and Housing for further action.
Okay. We can do that, and I don't think that Mr. Vanover would be upset by the motion.
No, I'm here. I'm here.
Oh, you are here, okay.
Mr. Chairman, no, I'm here. Yes, we would ask that you deny more time and remand it back to us for further action.
Okay, a motion is in order to deny more time, remand the property division of Building and Housing for any further action.
And
Motion,
Mr. Chairman, before you enter a ruling, I wanted to read the notice requirements.
Sure.
Yeah.
Sure, go ahead.
So through the chairman to Ms. Davis, did you receive any email, a note, any kind of communication on behalf of this appellant and or docket?
Through the chair to Mr. Jacobson, no.
And through the chair to Ms. Davis, did you send notice to the appellant?
Through the chair to Mr. Jacobson, yes.
To the chairman, the due process requirement of notice having been given to this appellant, the board can proceed with its hearing and ruling today. Thank you.
okay, motion
So moved.
moved by Mr. Dank,
Second.
second by Ms. Lipscomb.
Mr. Bradley? Mr. Dink?
Yes.
Ms. Lipscomb?
Yes.
Mr. Gallagher?
Yes. Okay, notice will be sent out within 2 weeks. Now. Or- That's the last docket, right?
That is correct, Mr. Chairman.
Okay. Approval of resolutions. Let's see what we got here. Okay, we got A 171-24 through A 179-24 and A 412-23. Motion?
So moved.
Okay, moved by Mr. Bradley,
Second.
second by Mr. Dank.
Mr. Bradley?
Yes.
Mr. Dink?
Yes.
Ms. Lipscomb?
Yes.
Mr. Gallagher?
Yes. Approval of minutes for February 12th, 2024. Are there any additions or corrections?
No.
Mr. Chairman, one more point of clarification. What was the
Yes.
status of docket A 182-24? In the shuffling,
Oh, you mean the last one we heard? No.
was that the last one?
States there.
I apologize.
Housing docket 182-24 has been rescheduled to March 26th of 2025.
Thank you.
Yeah. Okay. All right, where were we?
Approval of
Oh,
minutes.
approval of minutes, okay. Motion,
So moved.
okay, moved by Mr. Dank,
Second,
second by Ms. Lipscomb.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Ms. Lipscomb,
yes.
Mr. Gallagher.
Yes. Anything else to come before us?
No.
We had enough, huh?
Yes.
Okay, all right, good job.
Yeah, good job.
Okay.
All
In
right,
2 weeks.
okay.
See y'all.
Bye.
Thank
Aye.
you.